week from today, the EEOC takes on Abercrombie and Fitch in front of the Supreme Court. Back in 2008, Samantha Elof, a practicing Muslim woman, applied for a job at Abercrombie and Fitch. Now, at the time, she was wearing a hijab. The chain's dress code did not allow headscarves, though. Elof was ultimately turned down for this job after she scored poorly on the presentation portion of the interview. She went on to sue the apparel giant, and her case has since made its way all the way to the U.S. Supreme Court. Now, here to help us understand what is required of an employer in this type of situation is managing partner Paul Harding from the law firm of Martin, Harding & Mazzotti. Good afternoon, Paul.
Hi,
Thanks
Julia.
for joining us.
That's my pleasure.
Really interesting case here.
Sure is.
I guess to start off, what are the limits that are placed on an employer when they're interviewing a potential employee?
You know, I get that question every so often, but there's a tremendous amount of latitude that an employer has. Again, we want to hire the right person that's going to perform the right function, but you got to be careful to not be in violation of Title VII of the Civil Rights Act. You can't not hire someone because of their race, religion, age, or national origin. But if you kind of navigate around those, there's tremendous flexibility.
Now, when it comes to an employer having to accommodate an employee's individual lifestyle or religion, in this case with the Muslim woman, where that employee's beliefs or dress may not fit the nature or the theme of the business, how does that work?
Well, you know, the legal term is undue hardship, right? So if by accommodating someone, you're going to have undue hardship and kind of hurt your business, then you make the argument that we can't accommodate here. In this case, you know, they didn't allow hats, they didn't allow any of the employees to wear black. So they could have said, hey, you can wear the headscarf, it's going to be floral. Whether that would work for her, I don't know. But that would have been one of the reasonable accommodations that an employee or an employer can make.
Yeah, just some kind of way to work around it.
Yeah, work around it, and so it works for both parties.
Okay. The other thing is just in your opinion, what do you see being the major issue in this case?
You know, the Supreme Court and I are often at odds. You know, sometimes I know what they're going to do. I got a good theme of it. Here, I just don't know what they're going to do. I don't think this issue here has to do specifically with whether or not they violated, discriminated against her, and didn't give her reasonable accommodation. It has to do with what they knew at the time of the interview. Did they know what her lifestyle was? Did they know what the accommodation was going to be? Because the current rule says an employer needs to know about the lifestyle and examine the accommodation prior to hiring for there to be any discrimination case. And the fact that the Supreme Court wants to look at this gives me the impression they may be looking to change the rule, but we'll have to wait and see.
It's a really interesting case. I mean, I feel like something like this would get a lot of publicity.
It sure has, yeah.
Okay.
Yeah.
Thank you very much for joining us on the show today. Paul Harding from Martin, Harding & Mazzotti.